A bill has been introduced in Congress that would completely eliminate OSHA, the agency responsible for workplace safety standards across America. No more federal inspections, no more national standards, everything handed to the states and private employers. This is the Nullify OSHA Act, and today we examine whether it could actually happen and what it would mean for every worker and safety professional in 2026 and beyond. Right now, OSHA operates as the central federal authority for the American workplace. It conducts site inspections, levies fines, and enforces a uniform set of safety standards from coast to coast. Quick formal disclaimer. This video is for educational and informational purposes only. It is not legal or political advice. Always refer to official congressional sources for the latest bill status. This legislation acts as a stress test for the entire American workplace safety infrastructure, forcing us to ask what happens if the federal regulatory floor is suddenly pulled away. The primary sponsor of H.R. 86 in the 119th Congress is Representative Andy Biggs of Arizona. The bill is blunt. It consists of exactly 2 sentences designed to repeal the OSHA Act of 1970 and abolish the agency without a single provision for a transition or a transfer of duties. The political catalyst for this legislation stems from intense pushback against recent federal vaccine mandates, as well as targeted enforcement crackdowns on independent state programs, like the one in Arizona. H.R. 86 attempts to erase 55 years of federal safety oversight with a single stroke of the legislative pen. The argument driving this bill relies on a specific interpretation of the Constitution. Proponents argue that federal oversight overreaches into state police powers, the traditional legal authority of individual states to regulate the welfare of their citizens. This map illustrates their critique of uniform rules, like a national heat standard. Applying the exact same outdoor temperature regulations to a summer in Arizona and a summer in Maine creates regulatory friction for local businesses. Supporters believe that localized state governments and private employers are simply closer to the actual work, allowing them to manage safety more efficiently without waiting for a federal bureaucracy to dictate terms. To these proponents, OSHA acts as a bottleneck that penalizes states for their unique environmental and economic conditions. To evaluate the idea of returning to state control, we have to look back at the reality of the 1960s, the period before federal intervention. This chart shows worker injuries peaking before 1970. Disabling injuries jumped 20%, with 14,000 workers dying annually. Watch the economic mechanism, a race to the bottom. Without a federal floor, states lowered safety standards to attract businesses from neighbors. Today, this history creates a stark contradiction. Many multinational corporations oppose abolishing OSHA because navigating 50 different state safety laws is a logistical nightmare. Nationwide trade associations frequently band together to interact with one unified federal rule. Training staff on one national compliance manual is more cost-effective than managing 50 separate versions. Returning to a fragmented, state-led safety model would likely create legal and financial friction for the very corporations it appears to empower. Objectively, H.R. 86 has 0 current co-sponsors in the House and faces an insurmountable 60-vote threshold in the Senate. The actual threat to federal safety oversight is a bureaucratic tactic known as administrative ghosting. In practice, an administration can simply refuse to appoint members to the Occupational Safety and Health Review Commission. By denying the commission a quorum, it becomes paralyzed and cannot adjudicate contested citations. Political opponents do not need a repeal bill to pass. They can effectively neutralize the agency's enforcement power through budget cuts and intentional understaffing. If the federal OSHA Act were repealed, a legal domino effect would follow. Currently, 22 state-run OSHA programs are legally and financially tethered to the federal act. Removing that federal anchor immediately drops those state programs into a legal vacuum, where their enabling statutes may no longer be valid. The financial ripple effect starts with workers' compensation. Without predictable federal standards to mitigate risk, insurers expect workplace injuries to rise, which directly causes premium costs to climb for every employer. Employers would also lose their regulatory safe harbor. They would be thrown back into the unpredictable realm of common law tort liabilities, where they could be sued for negligence in local civil courts over nearly any workplace hazard. Eliminating OSHA does not eliminate regulation. It merely replaces federal inspectors with trial lawyers and unpredictable insurance overhead. Because federal oversight is facing a period of potential paralysis, companies can no longer rely on OSHA compliance as a legal shield. If the agency can't provide a definitive standard, the burden shifts to the employer to prove their safety metrics are defensible in court. Whether OSHA exists in its current form or not, the responsibility for keeping workers safe ultimately rests with every employer and safety professional. If you want to learn more about OSHA policy updates, enforcement changes, and workplace safety in 2026, subscribe to the HSEstudy YouTube channel. Click the links on your screen to keep exploring.